You know how much I enjoy social media.
Almost addicted, I'd say.
Yes. Something that is always interesting to me is reading on Facebook in community pages. There's always every week someone writing asking for information about wills or an estate matter, and sometimes reading the comments that people make on estate planning and wills and estate administration can cause my blood pressure to rise, and it take everything I can not to make my own comment. So today I thought I'd take you through just a post that I've found and some of the comments that people have made, what your response to those as a lawyer.
Can I make a guess before you read it out what one of the comments may be?
Sure.
I often see, well, if you give them $1, they can't contest it.
Well, let's see. So this person has written that they're going to have a vent about lawyers and wills, which is fair enough. We like to vent about lawyers. The partner and this person wanted to update their wills, and they were quoted about $600 each, which doesn't seem unreasonable.
No.
The last will they got before this included a testamentary trust at a cost of about $3,000, which again I don't think is unreasonable, and they want to go back to something more basic. This person realised that a lot of the will is just simply cut and paste from templates with an extreme amount of superfluous wording, and wondering why there was so much superfluous yet impressive looking crap in the will. At one point they say, impressive looking crap that refers to my children and grandchildren that will never exist, plus many things such as online accounts, adoptions, in vitro fertilisation, and God knows what else, including the dog next door might fart sometime in 2030. They really do think that lawyers try and make things look far more impressive and complicated than needs to be in order to justify their charges and give them the impression that you can't do without them. Where's the $600 value in a template? They just want everything to go to my partner, end of story. What's your immediate reaction to that perspective?
I can understand feeling as though it's needlessly complex. However, I've been in the position myself where you try to draft something very simple from the start, and then on review you look at all the possible outcomes that could arise, and there's need for adding extras there.
So let's look at some of the individual comments and we'll talk about those. This person says, you can write your will yourself and have it signed by 2 JPs. You can.
Yeah.
You don't have to have a JP witness a will. You just need to have 2 adults who are independent or not beneficiaries of the will, or related to beneficiaries is generally the best way of doing it. So we've just potentially saved that person the hassle of finding JPs to witness their will. This person said, get a will from the post office, cheap and easy, no lawyer needed, and still as legal. If it's executed properly, they're correct. It is legal, and it is probably certainly cheaper than seeing a lawyer. What's probably the downside to doing it yourself?
Not knowing the potential outcomes that could arise, not knowing how to word your clauses so that they operate as you intend them to. I think we have a post office will at the moment that's in court due to ambiguity of the clauses, and it's not something I expect clients to be able to consider, but it does happen.
If you need to make an application, or if the executors need to make an application for the interpretation of a will, do you think that's going to be more expensive or less expensive than the original cost to get
I
the will
can
done?
confidently say it will be significantly more expensive, and it comes out of your estate. So it's coming out of where you ultimately want that money to go. They're going to receive less as a result.
I think a lot of people don't always appreciate when you hire a lawyer or use a lawyer, you're doing 2 things. Ideally, you're getting someone with experience in the area you're seeking assistance with, but you're also engaging in our professional indemnity insurance. So if we do get something wrong, there is insurance and otherwise to back any mistakes that lawyers happen to make. A lot of will kit comments. There's plenty of free options now. Even ChatGPT can write you one.
I morally have a view on ChatGPT and AI. I have seen people ask ChatGPT to prepare things, and it has issues with jurisdiction. I don't think it necessarily is very good at weeding out international laws. If you're looking for an Australian will, you want it to consider Australian and then state jurisdiction.
Yeah, we're seeing a lot of people now make inquiries, people who have prepared their own legal documents via ChatGPT and then ask to send them to us and ask us to just do a quick review of what they've done to make sure it's right. Our response is generally, no, we can't do that. And
it takes more time to review these documents, and then at times to battle with the client on the advice that we're trying to give them as to why it doesn't work the way that they want it to. It's more cost effective for them to give us instructions, whole instructions at the start, and let us put it together for them.
I think the people who do that are often, they're aware of the professional indemnity insurance and they're looking to kind of have a bit in each camp where they're saying, I want to save money, so I'll draft it myself, but I still want a lawyer to sign off on it. It brings us back to the original comment that was made about paying for a template document. Many of the clauses that are included in our legal documents are drafted through years of experience in dealing with the things that can go wrong. We're not drafting things from scratch each time. We're drafting them based on, in my case, 25 years plus experience in the area.
And new case law that comes up every year where we consider our precedents again and again. And, those precedents have been formed over, as you've said, years. The price we are charging is by no means reflective of how much work has actually gone into those documents.
You'll like this one. Lawyers have a licence to print money. Get a will kit from a post office, they are legal. Where's your licence to print money? There's a couple of comments here. Go to the public trustee, they do them for free. Public trustee does wills for free. I think the public trustee has issues of their own. They're not lawyers who are preparing the documents typically in the public trustee's office. There were obviously some high profile parliamentary reports into financial performance of the public trustee, albeit in the phase of acting as financial administrators. Typically when you appoint the public trustee to act as an executor, for example, their fee charges on a scale, and they are often far more expensive than engaging a private lawyer.
Personally motivated to administer your estate either. I loathe to put any sort of intention on the public trustee as to why these wills turn out the way they do, or the matters are administered in the way that they are. However, as you said, are not lawyers, they are not giving you advice that you should get around what will actually happen when your will is used.
And again, because they're not lawyers, they don't have professional indemnity
or the same obligations that we have.
Here's a good one. I agree with this one. It's always so simple until it isn't. Might just save you a fortune in the long run if it is contested down the track. Do you have anything to object to in that comment?
Exactly, that's the point. A lot of people come to us and say, oh, it's just a straightforward matter. And then as we're talking to them, we find out that they perhaps have stepchildren they haven't considered, or past spouses who are likely to kick up a fuss, or even if they don't, their life, we hope, still has many years left, many decades left in most instances, and people often won't go and do another will, and we anticipate that when we're drafting these wills.
Yeah, ideally people would review their documents
and realise that they still work.
But in reality they don't always do that, and circumstances change, so we try and
account for that.
Yes.
Yeah.
What's the difference between having a lawyer and a car salesman draw up and witness a will? It sounds like the start of a joke, but there's no punchline in it. From a legal perspective, the difference is lawyers are actually legally allowed to draft wills and do those documents, whereas a car salesman who doesn't have a practicing certificate is precluded from providing legal advice.
And I'd want to check the beneficiaries named in that will as well.
Probably. This is a good one. Yes, especially when wills can be overturned by judges anyway if your will doesn't seem fair.
I appreciate the rhetoric around this one. There are people who are eligible to apply for further provision from the will if a court considers that they have not been provided for adequately, and I can understand the consensus that that's not fair. People should be able to do what they want with their money, and that is advice that we give to clients when they're telling us who they'd like to give their money to.
This comment that I'll read now sort of goes into the same implication. Doesn't matter how much you pay a lawyer or what you want or put in your will, if someone decides to contest it, they can. That's how lawyers make money, and it can get dragged out for years. Then it goes to a judge who, like a football referee, can make a decision on totally how they see the play and not your wishes. Lawyers and judges need to be held accountable for the emotional and financial hardship they cause. That's a lot to unpack. I think they're kind of blaming the lawyer. If someone wants to do something in their will and the will is later challenged, I'm not sure that that's
And I can assure people that there are
fault.
Many things in place intended to keep lawyers and judges accountable. Again, we're not getting into necessarily family provision applications today. What coming to see a lawyer can help you avoid, or can give you the tools to better address potential contesting in the future, is making sure we go through everything that is necessary before you sign the will, so that someone who's arguing that you were unduly influenced or didn't have capacity or didn't understand what they were doing can be argued with.
Yeah, morally just a bit below a used car salesman. It seems to be a lot of people
I don't want to spend this time defending lawyers. I think we're reasonably biased.
Let's defend used car salesmen. I don't think they're all bad either.
Well, subjective then. We'll just agree to disagree on that one. Again, we've got to charge for the work that we do. Clients can do what they're comfortable doing. It's not lost on me that things are expensive,
Yeah.
ultimately we consider there's far more value in spending
Yeah.
that money than not.
Yeah, it does boil down to there are many things that I could probably have a go at doing myself. I just think that with some things, I will get far more value paying someone for it.
This couple, if this original poster sees this video, I would ask them why they feel the need to change their wills if they're not prepared to pay for it now. They've got what sounds like a perfectly reasonable estate plan in place that they just would like to simplify. So they'll need to value whether simplifying their estate plan is worth spending the money.
Yeah.